and welcome to today's webinar where we are talking about tenancy agreements. And the reason we're doing this is quite often at UPAD we get landlords sending in their existing tenancy agreement that they want to use again the next time. And quite often there are either clauses in there that aren't enforceable, clauses that just shouldn't be in there or badly written, and actually short hold tenancy agreements, which are the main ones we're all using, although there's some others that we will cover off in a little bit, do get updated from time to time. Sort of at UPAD we use ALA, the Association of Rental Letting Agents, sort of template, which gets updated generally sort of twice a year. And I think it's really important to be aware of all of these issues, and that was sort of the backdrop as to why we're doing today's webinar. Just a bit of housekeeping. Hopefully everybody can hear me clearly and can see our sort of blue screen in front of you. If anybody has got any comments or questions they would like to pose, there is a chat box on the right-hand side of your screen. So please do send any comments or anything you would like us to talk about or answer for you towards the end, and we will cover them off as much as we can afterwards. There's about 30 minutes where we're going to run through this deck, and that should give us 10-15 minutes to cover off any questions that have come through. And if any of you miss any of it, you will be sent a recording afterwards so you can watch again or share with any colleagues that are landlords too. So I think that's the housekeeping bit over and done with. For those of you who don't know me, I've been a landlord for the last 18 years or so, and it was properties in Northwest London and Swansea that meant that I got cheesed off, I suppose, with the existing offerings that were there for us landlords. If you were using a traditional agent, I wanted to do my own viewings, and I actually had my own tenancy agreement that I was getting through the NLA, the National Landlord Association, but I still had to pay the full whack to the high street agent, and that didn't really sit well with me. If I choose to self-serve and use sites like Gumtree, I just found the quality and the quantity of inquiries I got was quite poor. What we now know at UPAD is that it takes something like 4 Gumtree leads to every Rightmove lead to let a property. So that's why we set up UPAD a few years ago. We've now become the largest online letting agent in the UK. And I'm immensely proud of the whole team who are all ALA accredited. But I'm proud in two regards. First of all is our Trustpilot reviews, which are the equivalent of TripAdvisor for us letting agents, and also the fact that we won the ESTA Best Online Letting Agent Award earlier this year. And this was voted for by consumers rather than a panel. So I'm really proud of the team and what we've built over the last few years, and the knowledge and shared guidance that we share with everybody. It's with great pleasure, yet again, to be doing a webinar with Tessa. Tessa and I have known each other for many years, I think, and she has an utter wealth of knowledge and insights on this particular front, and so we thought it would be worthwhile to drop a line to see if she would have some free time to join us today, but very much gets the legal side of being a landlord. Tessa, hopefully you are there and you can hear us, and we can hear you, hopefully.
Yes, I'm here, and many congratulations on your award, James. I wasn't aware of that. That's brilliant.
Thank you. A little sideline is when we were at the awards, I wasn't actually aware of either. I was chatting away to somebody, and it was only afterwards it was like, oh, we better go and get our awards. So a bit of a funny thing. But Tessa's got an utter wealth of knowledge. So between her and myself, please do send any questions through, and we will do our best to answer as many as we can. Try not to make them too specific. We'd like to try and keep them general so they're relevant for everybody that is listening in today. And it may be the case that it makes sense for you to contact Tessa directly, and her website and email address is in front of you. Our details will come up at the end if you've got a very specific inquiry that you want to follow up on. But in terms of an agenda for the next 30 minutes or so, what we want to cover off is as follows. What type of tenancy agreement you should be using based on your circumstances. The essential clauses. We're not going to spend hours and hours talking about each clause in detail, but just talk about the top ones that should be in there. We're going to cover off the right to rent side of things that we have to do. The Home Office brought into play fairly recently. We're going to talk about periodic tenancies versus renewal and what the difference is there, and the importance of having a solid tenancy agreement should you have to go through the eviction process. And the reason we mention this is something like 30-odd% of all landlords, have had rent arrears in the last 12 months. And I think it's important that you're protected. You have a document that can be enforceable should you need it at that particular time. So in terms of the types of tenancy agreements that are in play, these are the 6 sort of main tenancy agreements that are out there, depending on who your tenants are and whether you're letting out a room in your property, for example. Tessa, do you want to just give a quick overview? And we'll dig into the ASTs in a little bit more detail, because that's obviously in the main, but maybe let's just touch a little bit on the other 5 on there for now.
Okay, well, number 2, I mean, basically there's 2 types of legal occupation that you can have. One of them is as a tenancy, whereas you have a legal interest in a way in the property, and the other one is as a licensee, which is when you merely got permission to stay there. And the main licensee is lodgers. So if you rent a room in your house, in most cases that will be a lodger. They'll share your living accommodation. They won't have a tenancy, and they won't have the rights of a tenant either. Assured tenancies are very similar to assured short-hold tenancies, except they can't use Section 21. So tenants have long-term security, and they're used a lot by social landlords. Non-assured tenancy. I think that's what you mean by that, James, is when it's not an assured short-hold tenancy. Assured short-hold tenancies are regulated by the Housing Act, and the Housing Act has a section which says these types of tenancy are not going to be assured or assured short-hold tenancies, and there's a great long list. It's in Schedule 1, and those include things like people renting out their own home, companies, high rent, low rent, that sort of thing. And regulated tenancies, I think you mean the very old ones, don't you, James? The ones
That's
that
correct.
preceded 15th of January 1989. If you're buying a property and it's very, very cheap, you want to watch out with that, because it may be that they've got a regulated tenant in there and you'll never get them out, and that's why it's cheap. So you need to watch out for that.
And company lets are company lets.
Well, company lets are really technically the same as non-assured. It's just that it's the tenant. Some people sometimes get confused about it. It's not the landlord that's the company that changes. It's if the tenant's a company. And the reason for that is the Housing Act 1988, when it set up assured and assured shortholds, said that the protection is only for individuals. And of course, a company is not a living person; it's an artificial person. So that falls through, and it doesn't fall into the assured and assured shorthold. It's not possible for it to have an assured or an assured shorthold tenancy.
Thank you, Tessa. Much appreciated, and said very much clearer than I could have done. But clearly, the main one that all of us are seeing are ASTs, assured short-hold tenancy agreements. Generally, these are 6 or 12 months long. We have to make sure we're registering the deposit in one of the 3 government-approved schemes that are out there, and there's clauses that are sort of within all ASTs, or should be, that you can't raise the rent unless there is a rent review clause specifically in there, or the tenant actually agrees with it, and it goes periodic if it's not renewed. So at the end of that term, what it means is it goes periodic. There's slightly different criteria there in terms of the fact that the tenant can just give you notice at any point thereon in, and arguably so can you. There's sort of an equal amount of pros and cons about whether you should allow tenancies to go periodic or whether you should renew them with a new tenancy agreement. I suppose the jury's slightly out on which is better. It's just probably more of a preference. And the other sort of side of things that's sort of worth mentioning is sort of the non-assured short-hold tenancies if the rent is fairly low. Is there anything else you want to add to that, Tessa, that I haven't covered off yet?
Well, I think I've sort of whipped through most of these pretty swiftly in my on the other slide. I mean, I can talk about periodic and fixed term, but we've got a slide for that later on.
Fine. So this just gives a little bit more detail about each of the types of tenancy agreements that are out there. I think one for lodgers is increasingly quite common, where people are letting out a spare room. The government recently increased the rights, the amount that you can earn before having to pay tax on letting out an individual room. So, and I think that's increasingly becoming more and more popular.
Can I just mention something on that, James? I think a lot of people don't realise that for lodgers, you've also got to do a right to rent check for lodgers as well as for tenancies, and people don't always realise that.
And rather than going off at a tangent about what are the right to rent checks, there is sort of webinars we do on this. If you go to the UPAD homepage, upad.co.uk, scroll towards the bottom-ish, there's webinars we do on regulation, and we cover off right to rent there. Also within our blog, we got quite a bit that we cover off about what the procedures are there, but I don't want to sort of go off at a tangent on this particular one, on that particular front. Regulated, as Tessa said, are very much old school, as it were, very much buyer beware if there's a property that's come on the market well below its market value, something to worth be aware of, because you're hugely restricted on increasing the rent. And company lets are what they are. I think these are actually becoming a little bit more common as far as I'm seeing, Tessa. Are you seeing the same?
Well, I think quite a few landlords are putting their properties. Oh no, because that won't. I'm not sure. You will know more than me, because with my service, people join my service to use the information, but they don't always tell me what they're doing. So I don't always know unless they ask me.
It's just something we seem to be seeing more often. Now, there's essential clauses that definitely should be in every single tenancy agreement. Now, there's been a few comments that have come through so far. There are clearly loads of ways of being able to use a tenancy agreement. You can Google free ASTs, you can pay for them online, you can go to WH Smith's, you can go to a landlord association, you could use UPAD's one through Arla as a template.
Well, you could use ours, James.
And indeed, Tessa, sorry, it was on the tip of my tongue, Tessa. And I think what is important is to use a tenancy agreement where there's knowledge that it's going to be updated from time to time. So I'm always cautious about downloading something online for free. Sometimes there's a catch, i.e. it hasn't been up to date as it should be. The same
basically, you get what you pay for.
Yep. That's a very good point there, Tessa. You want to make sure you're using a tenancy agreement that is live, is active, it's been updated fairly recently, and make sure you don't just use that template for the years going forward, because there are amendments that occur from time to time that are worth using an up-to-date tenancy agreement. So don't think it's just a download one and that's it for the next 10 years. But these 11 points are the key areas that need to be covered off. Now, we could probably talk for a good 5-10 minutes on each of these individual bits. I suppose I'm just going to pick out a couple of things, and then maybe, Tessa, you want to pick out a couple as well. But for me, the pets clause is a big one. We get a lot of people in terms of landlords wanting clauses where pets aren't allowed. And actually, as a landlord, you can't reasonably refuse a tenant from having a pet. If, for an example, you have a 4th-story flat and it's sort of a staircase, there's no outside space in terms of a balcony or anything, to reasonably refuse a tenant from having a dog would be absolutely fair and reasonable. If it's a ground floor property with its own self-contained private garden, it's going to be a bit of a harder one to sort of get through on why you're reasonably refusing that. Yes.
If I could just mention, I mean, the point is that the clause has got to be drafted properly. There are regulations called the unfair terms regulations, and if a clause does not comply with those regulations, it will be void. So if you have a void clause, that means that the tenant can keep their pets and you haven't got a clause stopping you. And what makes a pet clause valid is having the wording save with the permission of the landlord, which will not be unreasonably refused. Now, if you have that wording in there, that makes the clause fair. And there are a lot of reasonable reasons for refusing permission for pets. I mean, there's allergies, the fact that they might damage the property, the fact that it's unsuitable. But there will be some pets where it will be unreasonable to refuse, like a stick insect in a jar or a goldfish in a bowl. So that is why the clause has to be drafted in that way, and if it's not drafted that way, then it will be invalid.
Thank you, Tessa. That's really insightful. What I would also add is about the amount of tenants that are allowed to be in the property. In theory, it's limited to those that are physically named on the tenancy agreement. There's a huge amount of subletting and friends being allowed to stay in an unprofessional capacity. But it's really important to make sure you've got these 11 clauses in there. These are the key bits that you want to make sure are covered off. Tessa, is there a couple that you want to just shed some light on?
Yeah, I mean, I can whip through them quite quickly. I mean, first of all, the deposit clause. You have to say in your tenancy agreement what you are entitled to deduct from the deposit. And if you don't have that in there, the tenant, you don't actually have a right to deduct anything, because it's not your money, it's the tenants, and the tenants authorize you to make deductions by signing your tenancy agreement. So if you don't have a clause setting that out, then you will probably lose at adjudication just on that point, or if you haven't got a tenancy agreement. Rent payable in advance. Under the common law, rent is payable in arrears. So if you don't have a tenancy agreement, or your tenancy agreement doesn't say the rent is payable in advance, then by default it will be payable in arrears, which you won't want. Right to rent conditions. I think we've got a separate slide for that, have we, James? So I can talk about that there.
Yeah, that's the next one, I think.
I'll quickly mention data protection because they are starting to tighten up on data protection. I think there's some new rules coming in next year, but you need to notify them that you are going to retain their information, that you reserve the right to give it out to the water board if they run away without paying their water bill. You need to be able to, you will want to tell the water board their details so that they can pursue them. I mean, that lots of people go without paying their water, and that's why water rates are quite high. So, you know, it's a sort of service that really for everybody. And also to notify them that you reserve the right to give their information to your process servers or your tracing agents if you want to trace them to recover money that they owe you. So these things need to go in data protection clauses, just so that you're okay in doing those things and don't have any problems with the Information Commissioner.
Thank you very much indeed, Tess. That's really thorough as far as I'm concerned. So from a right to rent protection perspective, and again, we cover this off in other webinars, but it's really important to make sure in the tenancy agreement that that everybody who is allowed to reside, all those occupiers who are allowed to be on the tenancy agreement, it needs to include children as well. And actually, one thing I'm just going to ask you, Tessa, is what happens if somebody has more than 4 people on a tenancy agreement? Because as I understand it, on an AST, you only have up to 4 individuals. So, you know, if it's 5 or 6 sharers, for example, on one agreement, how does that work? Or
no, that's not a problem at all. I mean, this is a landlord law issue, and under the Law Property Act, only 4 people can own the legal interest in land. But if there's more than 4 people named on the agreement, then the first 4 named will own it on trust for the others. I mean, with tenancies, we don't really bother about this sort of detail. You need to have them all named, though, because a tenancy agreement is this sort of weird amalgam of land law and contract law. And contract law doesn't have this limit of only having 4. So they need to be on the tenancy agreement, so you've got a valid contract with them that you can use if, say, for example, you want to claim outstanding rent. But I mean, I wouldn't bother about that particularly. I mean, it's a very technical thing, and just put their names on, and don't worry about that particularly. The right to rent protection thing, this here is a way that you can help protect yourself, because with right to rent, you know, you've got to check whether everybody living in your property has got the right to live in England and Wales, and the government are bringing in more rules. I mean, last year the legislature introduced criminal penalties for that, so it's quite serious. But if in your tenancy agreement you name everybody who's got to live there including the children. Now, children don't need to be right to rent checked, but you know, sometimes it's difficult to tell the age of someone if they're 16 or 17, so get proof of their age. So you have a list in your tenancy agreement of everybody who's living there. You make sure that you write to rent check those people, and then you have a clause in your tenancy agreement saying that no one else is allowed to live there. Now, I don't really think you can do much more to satisfy the Home Office if they come down and say, well, there's other people living there who are not, you know, who are illegal immigrants, because you will have checked everybody and you will have forbidden anybody else living there. And they can't really expect you to stand outside the door, the front door, checking the passport of everybody who goes in and out. So I just wanted to say that, because this is a way that you can protect yourself using your tenancy agreement.
Great, thank you very much indeed. I just want to touch on periodic tenancies versus renewals, you know, doing a new tenancy agreement. And I think it'd be good to get your vibe, Tessa, because from my perspective, wearing my landlord hat, is I actually just generally let things go periodic. Sometimes when there is a rent change, I will do a new one, or if the tenants have asked for a new tenancy agreement, there is this sort of psychological thing of having a new agreement that stipulates a start date and an end date, and it's seen maybe that it's more accurate than allowing it to go periodic. That might just be an educational thing, but there's pros and cons to both. I actually don't know what at large people tend to do, whether it's allow it to go periodic or change. But what are your thoughts on this one, Tessa?
I think it depends on the circumstances. If you want to increase the rent, then I think the best way to increase the rent is to give them a new fixed term tenancy, because they sign it and then they can't challenge it. Okay. Other than that, it's really how you feel about it. Now, the other thing is, if you've got a tenant in the property who you're unhappy about, say for example you've got tenants who have been behaving very badly, they've been having loud parties, da-di-da-di-da, they're upsetting the neighbours, and you say, look, you know, I'm going to let you stay there, but I want you to behave yourself. Now, the last thing you want to do for those tenants is to give them another fixed term tenancy of 1 year, because you won't really be able to get them out during that year, because you won't be able to use Section 21 during that period. So if you've got someone where you're not certain whether you want them to stay, if you're sort of putting them on notice, then having it go on a month-by-month basis is better, because if they start behaving badly, then you can serve a Section 21 notice on them. It's also good to have it rolling on as a periodic if both you and the tenants are uncertain. I mean, sometimes tenants are not entirely sure what their plans are. They may be moved to Gibraltar, they may not. So it's a lot more flexible if you let it run on a month-by-month basis, or possibly you may not be quite sure of what your plans are. So in those circumstances, again, a long fixed term is not a good idea. I will also mention here that your letting agents will often suggest to you that you have a long fixed term, and you need to be careful about this, because often they do that because they want to collect their commission. And renewals is another a trigger for them to collect a fee, and that's often, sadly, why they do it. But you need to think about whether it's right for you.
I think it's just like gut feel as well, based on everything that you've said, taking all of these things into account. I think that's all very relevant, and it's just how a situation occurs, I think. So it's good just to sort of touch on that as a subject matter and what we all think. Now, evictions, clearly none of us want evictions to occur. I think a lot of this is all about the prep work, making sure your house is in order, you have done inspections, you have been on top of rent stays to make sure that the tenants are up to date with their rents, and clearly not having your head in the sand for 2 or 3 weeks and not reaching out to your tenants to sort of say what's going on. But outside of what one should do in terms of rent day and so on to make sure you're on top of everything, and again, we cover a lot of evictions off on a separate webinar, which you can see from our homepage. it's really important to make sure that you're legally covered with the agreement that you have in place. Otherwise, you're sort of stuck in terms of being able to enforce things. Now, Tessa, from your perspective, what would be sort of sensible do's and don'ts from a landlord's perspective to make sure that they are able to enforce what they want to if there are sort of rent arrears building, and therefore somebody wants to evict?
There's a very technical thing that you need to be aware of. I think it's Section 7 of the Housing Act 1988 says that if you want to rely on one of the grounds for possession, and in particular here we're talking about the mandatory rent arrear ground, if you want to use that during a fixed term, you've got to say that in your tenancy agreement. You've got to have a clause in your tenancy agreement which tells them that you reserve the right to use one of these grounds. And this is often put into a clause that's called a forfeiture clause. Now, you can't forfeit assured short-hold tenancies, but we still often still put that wording in because it is possible for a tenancy to change from an assured short-hold to an assured in certain circumstances. And so we put all those things in the same clause. I think also it's very important that you actually have a tenancy agreement because there is this special procedure for bringing possession proceedings, which is reserved just for claims based on Section 21. And it's called the accelerated procedure. It's a bit of a joke, really, because it's not that quick, but it is preferable to use it, partly because there isn't a hearing, partly because it's very much limited to Section 21. It's more difficult for your tenants to put in a counterclaim. And you can't use that procedure if you haven't got a written tenancy agreement. And the reason for that is the judge decides on the paperwork. So if your paperwork's missing, you can't use that procedure.
Thanks, Tessa. That's really, really appreciated. I think the other bit that's worth just sort of talking about is using a language that everybody actually understands. And that said, even if you are using the tenancy agreement that is written in sort of plain English where possible, I do think it's worthwhile sitting down with your tenant and just going through each of the clauses so that they understand it. It's so common that when you sign a tenancy agreement, you rent a car overseas, what have you, you just go to the end, sign your name and move on. But I really think it's worth our while from a landlord's perspective to ensure our tenants know what they're signing up to, whether this is to do with the cleaning of the property, the laundering of curtains and furniture and so on at the end of the tenancy agreement, pets and so on and so forth. It's really worthwhile, I think, to try and use plain English as much as you possibly can and to actually sit down with your tenants still to make sure they get it, rather than just there's this assumption they've signed and therefore that's okay. Yes, you're legally covered, but actually to sit down with them, I think you're going to overcome various issues that are very likely to sort of come up over the course of the 6 to 12 months, as it were, coming up. Is there anything you want to add to that?
Yeah, I mean, I think generally with drafting documentation and the sort of plain English thing, that the government is tending to want to see these documents both as being a legal document, but perhaps also a guidebook as well. Perhaps it's like the tenancy agreement is also a handbook for tenants, telling them how they can use your property. So putting it in plain English means that they can understand it. I mean, you know, a lot of tenants, English won't be their first language, so it needs to be very clear. Other things like putting all the clauses in the same topic in sections on their own is a good idea. I mean, it's quite a long time ago now, I think it's about 2009, I sat down and I completely redid all my tenancy agreements and put them in a plain English format. And two of the main things I did, one of them is instead of saying the landlord thinks that the landlord and the tenant, I talked about we and you. And it's surprising the difference that makes. It makes it a much more approachable document. And another thing,
good idea.
I split all the clauses up and jiggled them around. So all the clauses about health and safety are there. All the clauses about locks and keys are there. All the data protection clauses are there, and they've got headings as well. So it's very easy for people to find their way around, as well as being in language which is easier to understand.
So there's various places you can get a tenancy agreement from. Obviously, I sort of forgot about Tessa's website, but her website's on there, landlordlaw.co.uk. Obviously, there's others you can get from the government website. We do our own. We do it slightly differently in terms of we use ours as a template, but then what we've found is that the average landlord wants 2, 3, or 4 additional clauses. Now, this may be because it's a leasehold property, as an example. So we've got a whole bunch of additional clauses that we've got sort of ready to go based on people's specific circumstances, including rent reviews and what have you. So the way we work is we have this template, and then we've got sort of several hundred exceptional clauses ready to be used as and when people want them to be included. But they've all gone through the whole legal process, as it were, so they're legally enforceable. It's not like me writing them. It's from a legal perspective, because I also just don't believe that just like a template necessarily works. But it's worth bearing that in mind. Landlord Action is a business that I've known Paul Champolini for quite some time, who runs that company for evictions. They're nationwide, and again, I actually think evictions are annoyingly quite complicated, and it's very easy to fall over and not submit the right information at the right time, and therefore it doesn't go through court, and you sort of start back at the start line again. So I'm a big fan of outsourcing that to a specialist that it's their main job. But it's probably worth making a note of those web addresses for businesses that I would recommend looking at. So in summary, just to sort of recap a bit on what we've gone through, and again, you know, there's a limit to what we can cover off in a 30-minute webinar, and this is more to give sort of a flavour, I suppose, is make sure that the tenancy agreement you're using includes all those 10 or I think 11 clauses that we talked about earlier. Make sure that it's up to date and regularly up to date. We update ours at UPAD sort of twice a year, which is when Arla do theirs. So, you know, if you're using one from 3 years ago, there's likely to be a variety of amendments from what it was back then. Make sure you review your tenancy agreements annually. I put a date in my diary for my CP12s, gas certs, when they're renewed, but also when tenancy agreements come up. It's important to reach out to your tenants maybe 1 or 2 months before a tenancy comes to an end, to ask them what they want to do, and whether it's going periodic or otherwise. Don't leave it sort of after the event, as it were. Maybe look at doing some training. I mean, Tessa does a whole bunch of this. She you know, there's conferences that Tessa does sort of on the subject matters. There's others obviously as well, but it's important, I think, to be up to speed yourself, rather than the idea of just outsourcing all of this to somebody else and just expecting them to understand what's going on. It's important that you understand the whole process. And we talked a little bit about using plain English. The you and I bit, I quite concur with Tessa. I can see the logic behind all of that. So do consider that when you're putting it together a tenancy agreement. And then the final bit before we do sort of Q&A session is in the right-hand side of your screen. There's some handouts you've got there in terms of how to choose the right tenant. There's a checklist, and then there's the Section 21 flowchart. Now, the reason I put that in there is because evictions and rent arrears are increasingly on the rise, unfortunately. I think that's going to happen more so as landlords try and recover the additional tax that they have to pay following George Osborne's decision last year by increasing rents, and I think that's going to have an adverse effect. So do download them before the end of this webinar, although I think they get circulated afterwards with a copy of the recording for this particular webinar. And do look at our homepage, upad.co.uk. There's generally 1 or 2 webinars every week that we are doing now, whether it's to do with tenancy agreements or deposits or legislation, tax, finance, and so on. So do check it out there. And if you're into the whole social media thing, you can follow us on Facebook, Twitter, and LinkedIn if that is your thing. So if you haven't had a chance yet to submit a question, or you've got a comment, please do so. You can send any questions through to us for the next 10-15 minutes using the right-hand side of your screen with the chat box, and we'll try and answer as many of them as we can. Tessa, I promise I won't forward on any difficult questions to you and try and balance this all out and keep all of this fair and keep it sort of friendly. But here's one that I generally don't know the answer to, and you probably do. But if you don't, we can come back to this afterwards with the person concerned. But on company lets, is there a minimum period that an agreement has to be for? I.e., does it have to be for at least 6 months? And does there also have to be a deposit on a company let, and does that need to be registered? So 3 parts there.
No. In fact, there aren't any types of tenancy where you've got to have a minimum period. With assured and also assured short-hold tenancies, there is a limit to, there are time restrictions now on serving Section 21 notices. When assured short-hold tenancies first came in the 1980s up to 1997, there was a minimum period of time that you had to give a fixed term for, but that went away a long time ago. You can have a fixed term for any period. You can have it for a month, you can have it for a year, you could even have it for a week if you wanted. So far as deposits are concerned, it's entirely up to you whether you take a deposit or not. The tenancy deposit regulations, which require you to protect a deposit with a scheme, only applies to assured short-hold tenancies. So if it's not an assured short-hold tenancy, so if it's a company let, or if it's a lodger, or if you're renting out self-contained accommodation in the building you live, then you don't have to protect it. Although obviously you need to look after it because it's not your money.
Thank you. There's been a couple of questions we've had that are sort of related in terms of somebody saying what happens if I'm using a tenancy agreement which predates recent changes. Others, if I'm using a tenancy agreement from 3 years ago, what's the best thing I should do? So let's assume there's a tenancy agreement in play, Tessa, and it started 6 months ago. If this now the landlord understands is an old agreement and there's updated clauses, would you suggest somebody informs the tenants of that and does a new agreement that's up to date, whether it's from your site or UPAS, for example, or just stay put until renewal date? What would be your recommendations there?
Well, I think you're probably okay, unless it's something really, really serious. I mean, the tenants don't have to sign it anyway. I mean, that's one of the reasons why you have to get a tenant to sign the tenancy agreement before they go in, because as soon as they've taken the keys and shut the door, they can turn around and say, I'm not signing that. So even if you did want them to sign it, they could refuse. I think it's best to do it at renewal. I mean, this is one of the reasons why long fixed terms are not a good idea, because you may want to update your tenancy agreement, or you may want to change the rent. I mean, often if you've got an old tenancy agreement and say it's got a clause that is couched in unfair language, the result of that is the clause won't be valid. You won't be able to use it. But it's quite rare for there actually to be litigation about that sort of thing. You should,
Fine.
as long as it's not a very long fixed term, you should be okay.
Thank you. Now, we've had several questions on this particular one, and it comes up quite frequently as well, actually, which is about the delivery of notices and so on to your tenants. And I might just sort of start off on this, and again, I don't think there's this sort of black and white answer. In terms of notices, you can post normal post to your tenants, you can do recorded delivery, you can hand deliver. And I think the jury is out on what is the preferred option.
I know what my preferred options are.
It'd be interesting to see whether we both match up. My preferred option is to be hand delivered, and the reason being, if you do normal post, there's an argument it was never actually received. If you do recorded post, getting that red slip or being asked to sign for something, some people may not choose to do so if they are knowing that they are 2 months, for example, in rent arrears. but by hand delivering it, and I recommend taking a colleague or a friend along with you at the same time to photograph you, which gets, on your phone, which gets date stamped as you're putting the envelope through the letterbox. I think all in all is probably the preferred option from my perspective. Tessa, are you going to say something very different now?
No, I'm not. No, I'm absolutely one of. If you are serving a document, which is one of the documents where I think are critical documents, which are ones where perhaps you're going to hang a court case on, classically serving possession notices, and also, hand delivering the prescribed information and notice of rent increases. Notices are going to be really important. You've got to bear in mind when you serve them that one day you may need to prove to a judge that you served that with the tenant standing on the other side of the desk swearing blind they never had it. So you've got to be able to retain sufficient records to prove that you did actually serve it, and hand delivering it with an independent witness is good. Another good way to do it is to get them to date and sign a copy of it. This is often a good idea if it's initially a non-contentious document, like for example with the prescribed information. If you do that though, be careful. I once had a case where the tenant had signed and dated it, but he put the wrong date on there. So for God's sake, check that they're putting the right date when they're signing and dating it, because otherwise that could get you into trouble.
As a bit of a sideline, when we have to do checks as far as smoke alarms and so on are concerned, getting your tenants to confirm with a note that the smoke alarm is working on the start of the tenancy agreement, the same with giving them all the prescribed information, the right to rent documentation, and again we cover all this off in other webinars, is really important. So Tessa's point I think is quite valid there about getting your tenants to specifically sign for something. Tessa, is there a minimum age from a trial perspective where you have to do right to rent checks? Is it 18 plus or something different?
Well, you don't have to do a right to rent check for minors. So that's not people who go down in mines, not that we've got any of them in this country anymore, but it's children. So if they're 18 or more, you need to right to rent check them. If they're under 18, you don't need to right to rent check them. But if they're sort of teenagers, I suggest you try and get proof of age, because as I said, it's difficult sometimes, particularly with girls with all the makeup. It's sometimes a bit difficult to tell whether they're 17 or 19. So get proof.
Thank you. And then just a couple of questions we've had, and I'm going to make an assumption as far as Tessa's concerned, but everything we've been talking about this evening is covered off within UPAD's tenancy agreement, and I'm assuming that's the case for your Tessa's on your website too?
Yep. Yeah, definitely. I mean, we check them quite regularly.
Is there any reason why you can't do a 2-year AST or 3 years perhaps?
No, there isn't any reason, but I don't think it's a very good idea. Certainly not with a new tenant. If you have a new tenant and you give them a 3-year tenancy, what sometimes happens, if it's arranged through an agent, the agents will take 3 years worth of commission up front. And then perhaps the tenant falls into arrears of rent. Now you can't serve a Section 21 notice to get rid of them because you've got a long fixed term. So you can't evict them under Section 21 until the end of the fixed term. If you're really, really unhappy with them, it may be impossible to get them out. So I think at least give them a modest fixed term for a new tenant, because you don't know what they're like. They may turn out to be total nightmare tenants, and they may prevent you from using the mandatory rent arrears ground by, keeping their rent arrears to under 2 months. So you could have problems.
And slightly going off the tangent, there was this a lot of noise politically about wanting to have longer tenancy agreements, and interestingly, it was more tenants that didn't want a longer tenancy agreement because they wanted that sort of flexibility.
Yeah.
I do think there's merit in that. Rather than trying to lock in for sort of 3 years or 2 years, I think it can very much work against you on that particular front. I think we've got time for one more question, and I'm going to end with this one because I think it's very relevant. It applies to a lot of people, and I think it's going to become a bigger thing. And this is somebody who's messaged us to say, what do you think we should do if the person that is on the tenancy agreement, the tenant, now has a boyfriend or indeed this applies in a variety of different cases, living in the property who is not on the tenancy agreement. In terms of the best course of action, what would you recommend, Tessa? And there's probably a couple of things I'm going to mention afterwards, and then we'll sort of call it a day there.
Well, I mean, it really depends on whether you're bothered about it or not. I mean, if they're helping to pay the rent, and they help look after the property, maybe they take their turn with the cleaning rota, there may not be a huge problem. If there is someone that you are unhappy about, then the only real thing that you can do is say, look, I don't want this person there. If you don't if they don't move out because they're damaging the property or whatever, I'm not going to be able to allow you to stay after the end of the fixed term. And again, this comes down to not giving long fixed terms. It really is against the landlord's interest to give a long fixed term, because if there is any problem during that fixed term, you cannot use Section 21 to remove them. I mean, it sounds harsh and awful, but looking from the landlord's point of view, that's the way it is.
Thank you, Tessa. Look, we're pretty much out of time. Just a couple of bits I was going to add to that. Actually, is really important to do routine inspections, whether that's monthly or bi-monthly, to understand what's going on in the property. I generally would have an issue if it was being sublet or a friend was living there, but I think you need to understand the situation. So from Tessa's perspective, it's more of it's okay, but I do think you need to understand the situation, okay. Or not to sort of enforce the law as soon as. I think you need to understand the situation and not just sort of jump at it. But I think you should make a judgment call based on everything that is put in front of you about how you want to react to it. And there's probably a sensible stance of dropping them an email or writing to them, say that I'm aware that your boyfriend or a friend is residing in the property that's not on the tenancy agreement. This is against what we have agreed to. I wouldn't say that you accept it, but I would make them aware of the fact that you know and that there is a breach of the tenancy agreement. And probably the same thing applies with other areas of the tenancy agreement, that I would do very much a similar thing. Look, we're pretty much out of time. Sorry, we're just pretty much out of time. We're slightly over at the moment. We could talk for hours on this, but I think it was important just to do a snapshot on tenancy agreements and just the key bits to be focused on. Hopefully everybody's got some learnings from this. There will be a copy of a recording of this that will be sent over email shortly with those handouts. If anybody would like to follow up, the UPAD details are in front of you, and Tessa's website, landlordlaw.co.uk. Please do check out. There's a wealth of information on there. Tessa, thanks again so much for joining us today. It's really appreciated. You have a wealth of knowledge, and it's always fun to do these things with you. So thank you very much yet again.
Thank you for inviting me. It was brilliant.
All right, all the best, Tessa. Take care, and thank you everybody for joining. I wish you all the very best and look forward to seeing you on our next webinar. Take care, all the best.
Thank you. Bye-bye.